Yes, ma'am. If it's not your case, please, I'll appreciate if your microphone is muted until your case is mentioned, please, so that we won't have back. Thank you. So mention the case, please.
Order at Kaduna Division before His Lordship, Honorable Justice A.O. Adeli, case number 1, NICS/KD/08/2016, between Jonathan Moses and 1, the Governor of Kaduna State, 2, the Governor.
I can't hear you properly. Can you please speak up louder? I don't even know which case you're mentioning now.
Case number 1, NICS/KD/08/2016 between Jonathan Moses and 1, Kaduna State, 2, Kaduna State Government, 3, the Commissioner, Ministry of Education, Science and Technology, Kaduna State, and all parties absent.
Understand that both counsel in the parties, both counsel in the case, adjournment. Case is adjourned to the 31st of October, 2022 for adoption. Yes, the next case. Can you call the next case?
Case number 2, NICS/KD/32/2019 between Mr. Balogun Agbaje Oladapo and Litramet Publication Nigeria Limited. My lord, parties absent.
Hello, the parties are not in court.
Yes,
my name is Masood Alabelewe. I humbly announce the appearance for the claimant, my lord.
Yes. No representation for the defense.
Hello, it appears the defendants are not represented. Lord. There's no representation for the defense, my lord.
Yes, sir. The case is for adoption.
But that is that, yes, my lord, we have filed a written address. We have filed a written address dated the... My lord, we filed a written address dated the 16th and filed on the 16th day of July, my lord. As dated the 16th of June and filed on the 16th of June 2022, my lord. We adopt the said written address.
Same has been
served. Our final address in this matter.
Same has been served on the defendant, sir. Yes.
Yes, my lord. Both electronically and physically, my lord.
Yes. You adopt same.
My lord, we adopt the address, yes, my lord, as our argument in urging the court to enter the judgment for the plaintiff, my lord.
Yes, thank you. Yes, court case is adjourned to the 23rd of November, 2022 for judgment.
As the court please. Almost with.
Hearing notice is to be served on the defendant, please.
As the court please. Almost with.
Yes, next case, please.
Case number 3, NICS/KD/04/2016 between Mr. Marshall Gawan and Arizona Printing and Publishing Nigeria Limited. 2, Mr. Ahmed A. Hussein. My Lord, please absent.
Yeah, are parties in court?
No, my Lord.
Appearances, please.
With profound humility to my Lord, L.M. Shah, for the claimant. For the claimant.
Thank you.
May it please the Honorable Court. My Lord, A.A. Lanley, Your Lordship, I hold the brief of Mr. Lanley for the defendant.
Sorry, I heard your whole name. Who are you holding brief for?
Mr. Lekan Yerinde, Olalekan Yerinde, sir.
Judgment. Yeah, this suit has a checkered history on record. It is the oldest case pending before this court as at date. It was instituted by the claimant on the 28th of January 2016. As borne out by the records, this case was commenced by His Lordship, late Honorable Justice Lawal Mani of blessed memory, and started de novo on the 17th of October 2018. The proceedings in the suit had been plagued by unending objections, attempts by parties to settle out of court, change of claimant's counsel, and countless applications for adjournment, which the court had to accommodate in the overstretched interest of justice that covers all sin. By the operative amended complaint and statement of facts filed with the leave of court on the 5th of March 2021, the claimant claimed against the defendant's relief set out as follows. To save the time of the court, the reliefs is as stated on the face of the judgment. In a nutshell, the case of the claimant is that on the 17th of December 2012, he sustained grievous injury on his hand while he was dislodging blockage from the stitching machine of the first defendant. The claimant alleged that part of his duties was to dislodge blockages from the said machine. On the fateful day, the machine had shut down due to blockage, and the claimant alleged that he was instructed by one Hassan Taufik, the operator of the machine, to dislodge the blockage. According to the claimant, the second defendant, without observing safety protocols, switched on the machine while he was still dislodging the blockage, which resulted to grievous harm to his hand. The claimant contends that while he was recuperating from the injury, the first defendant wrote a letter alleging that he had abandoned his duty. He further contends that the defendant neglected and or refused to pay for the cost of obtaining a functional prosthetic limb, and that his wife and children have suffered untold hardship resulting from the defendant's actions. The defendants joined issues with the claimant by amended statement of defense filed on the 10th of April 2017, whereby the entirety of the claimant's claim was denied, contending that the claimant was employed as a casual worker, and that his sole duty was to clear waste products from the stitching machine and not to dislodge blockages as claimed, and as such, the claimant had acted outside the scope of his duties and without instruction by dislodging the blockage from the machine on the said date. The defendant also alleged that the claimant ignored safety protocols to avert the injury. The defendants further alleged that the process for the payment of the claimant's claim for injury under the Nigerian Social Insurance Trust Fund, NSITF, was frustrated by the claimant by his refusal to sign documents to process his claims. The defendants further contend that the claimant's claim for negligence for disability is not justiciable, not being in accordance with the provisions of Employee Compensation Act 2010. The claimant's amended reply to the statement of defense was filed on the 10th of March 2021. At the plenary trial, the claimant testified as CW1 and fielded as CW2 were Godwin Jonathan. He tendered 4 documents in support of his case. Both witnesses were duly cross-examined by the defendant's learned counsel. In turn, the defendant also fielded 2 witnesses. One, Livinus Okpara, testified as DW1, whilst the DW2 is Hassan Taufik, the machine operator of the first defendant. Both witnesses adopted their respective statement on oath and tendered 8 documents in evidence as exhibits. They were both equally subjected to cross-examination by the claimant's learned counsel. Upon conclusion of plenary trial, parties filed and exchanged their written final addresses in compliance with the provisions of Order 45 of the rules of this court. The defendant's final address, filed on the 15th of October 2020, was adopted on the 28th of June 2022, whereby, defendant's final address was filed on the 15th of October 2020, adopted on the 28th of June 2022, whereby the learned counsel, Olalekan Oyeride Esquire, formulated 2 issues as having a reason for determination in this suit, namely, whether claimant's action is competent, and if issue 1 is answered in the affirmative, whether defendants were liable in negligence as alleged by the claimant. In the final address filed on behalf of the claimant, deemed filed on the 6th of April 2022, the learned counsel, L.M. Shao Esquire, identified a sole issue as arising for determination in the suit, that is, whether or not, having regards to the evidence laid and the circumstances of the suit, the claimant is entitled to relief sought. The reply on points of law was filed by the defendant on the 11th of April 2022. On the basis of the claimant's claim, the relevant evidence adduced by parties at the trial, and the totality of the circumstances of this case, my view is that the focal issues that call for resolution in the suit without prejudice to the issues raised by the parties could be succinctly framed as follows. 1, whether the claimant has established by cogent and legal evidence that the defendants breach the duty of care as its employer and thereby entitled to damages, compensation for the injury sustained. 2, whether from the totality of evidence laid and the circumstances of this case, the claimant proved his case for reliefs claimed. I have also taken cognizance of the totality of the arguments canvassed by respective learned counsel in their written addresses, to which I shall endeavor to make specific reference as I deem needful in the course of this judgment. I shall take both issues together. The case of the claimant as CW1 is that he was engaged in October 2012 by the first defendant, and part of his duties was to remove waste generated by the stitching machine and removal of paper or book stock in the machine. He described the operation of the machine and narrated the incident that occurred on the 17th of December 2012. According to the claimant, after the machine had shut down, he was instructed by the operator, 1SN Telfik, to dislodge the blockage in the machine, that he put his hand to dislodge the blockage after the said operator had signaled to him that it was safe, but that while he was still dislodging the blockage, the second defendant, without observing the safety protocol, turned on the machine, which occasioned the grievous injury to the palm of his left hand. The claimant alleged that the injury he sustained resulted from the negligence of the defendants, and further testified that he was treated at the hospital, but he has since suffered excruciating pains on his hand, and that he can no longer walk as a result of a permanent disability caused by the negligence of the defendants. It is the further testimony of the claimant that on the 10th of March 2015, he approached the National Orthopedic Hospital, Idigbe, Lagos, for a possibility of obtaining a functional prosthetic limb, but he was informed that this was unavailable. On further inquiries by his counsel, Mrs. Z.A. Munto Elemi at Bactrial Hospital, New Delhi, India, she got a pro forma invoice of $91,000 as the cost of the prosthetic limb and 380,000 naira as the cost of return tickets to India. To corroborate the testimony of the claimant that he was instructed by the operator to dislodge the blockage, CW2 testified that he was at the scene when the claimant was instructed to remove the blockage from the machine, and the accident occurred when the second defendant switched on the machine without observing the safety measures. In further support of his case, the defendant's letter dated 8th of February 2013, letter of National Orthopedic Hospital dated the 1st of April 2015, picture showing the injured hand, letter of Revelix Travels and Tour were admitted in evidence as Exhibit C1, C2, C3, and C4 respectively. The defendants also fielded 2 members of our staff as witnesses. They both denied that the claimant was instructed to remove the blockage from the machine and that a safety precaution had been provided for the machine, which the claimant failed to apply before the incident. DW1 testified that the defendant had notified the claimant before it started the process of his claim under the NSITF, but that the claimant refused to afford the first defendant with his passport photographs, the picture of the injured hand, and that he refused to sign the NSIT forms and thereby frustrated the process of his claim. The following documents were tendered to further buttress the case of the defendant, namely invoices of St. Gerard's Catholic Hospital for the claimant, Exhibit D1, letter of first defendants to claimants with NSITF forms attached, Exhibit D2, NSTIF notification of accident form, Exhibit D3, NSTIF claim form, Exhibit D3A, letter of NSTIF to first defendant dated 20th of February 2017, Exhibit D4, letter of first defendant to claimant dated 1st March 2017, Exhibit D5, NSITF employer's schedule of payment, Exhibit D6, and receipt of first defendant's contribution to NSTIF, Exhibit D7. I consider it very pertinent at this juncture to determine the issue raised by the learned defendant's counsel in his written address on the competency of the claimant's action and the jurisdiction of the court to entertain same. I should restate the age-long settled principle of law that the question of jurisdiction goes to the root, fiber, and foundation of a case, and thus must first and foremost be considered as it forms the basis upon which a court can entertain a suit. Jurisdiction gives life or otherwise to a suit. When it is raised at any stage of trial, the court will have to determine whether the subject is within its adjudicatory power. C, NURTW and another versus RTEAN 2012 LPELR 7840, Humbas Motel versus Wema Bank PLC, Anyawu and Ogule with citation supplied. It is not in doubt that the claimant's case for damage arose from personal injury, which is sustained as an employee of the first defendant. The argument of the defendant's counsel is that the claimant's action founded on thoughts of negligence is bad by the provisions of Section 12(1) of the Employee Compensation Act 2010, and further argued that the claim for negligence in respect of injury leading to disability, as in the present case, will not be justiciable except in accordance with the said provision. In response, learned counsel for claimants in urging the courts to discountenance the submission of learned defendants counsel placed reliance on Section 12, Section 12(6) of the ECA 2010 and submitted that it is not mandatory for employees to claim under the Act as argued by the learned defendants counsel. Learned counsel further submitted that an employee or any person claiming under the Act have an option to elect to either claim under the Act or resort to claim in negligence under common law. Now, Section 12(1) of the Employee Compensation Act 2010 in contention provides as follows, I quote, "The provisions of this Act are in lieu of any right action, statutory or otherwise, founded on a breach of duty of care or other course of action, whether that duty or course of action is imposed by or arises by reason of law or contract, expressed or implied, to which an employee, dependent, or member of the family of the employee is or may be entitled against the employer of the employee or against any employer within the scope of this Act or against any employee in respect of any death, injury, or disability arising out of or in the course of employment, and where no action in respect of it lies." With due respect, the interpretation of learned defendants counsel that the claimant's action is bad by the provisions of Section 12(1) of the Employees Compensation Act is totally misconceived. By my understanding, the phrase "in lieu of" in the Section 12(1) ECA can be defined as instead of or in place of. As correctly submitted by claimant's learned counsel, it denotes that claiming under the ECA 2010 is an alternative right of action, statutory or otherwise, either founded on breach of duty of care or any other course of action. In other words, the Act allows a claimant to elect to either claim compensation under it or claim in negligence under the common law. I totally agree with the submission of learned claimants counsel that Section 12(1) ECA does not bar the claimant's action as erroneously submitted by the learned defendants counsel. On the score, therefore, the claimant's action is competent. The court has jurisdiction to entertain the action, and I so hold. The case of the claimant as told by him is that he was injured while he was working in the defendant's employment. The defendant admitted this much in paragraphs 8 and 10 of the amended statement of defense. The dispute between parties is, however, on the liability of the defendants for the injury. The claimant alleged that the injury was as a result of negligence of the second defendant, who was a co-worker of the first defendant. The particulars of the negligence, as alleged by the claimant, as stated in paragraph 14A to J of the witness statement on oath. The defendants totally denied the allegation of negligence. The issue to be resolved here, which perhaps is the crux of this action, is whether or not, on the basis of the evidence led at the trial and the applicable legal principles, the claimants have succeeded in establishing a case of negligence against the defendants. From time immemorial, the general principles guiding the proof of a claim for negligence have remained sacrosanct. Therefore, in order for a claimant to succeed in an action for negligence, it is required in law to establish the following elements without exception. Namely, 1, that the defendant owes the claimant a duty of care. 2, that the defendant has acted in such a way as to breach that duty of care. 3, that the conduct of the defendant was careless and consequently occasioned the damage or loss suffered by the claimant. It is therefore after a claimant has satisfactorily established these 3 elements or ingredients altogether by credible evidence that a defendant can in law be held liable for negligence. See Anya versus Concord Hotel, United Trust Bank of Nigeria versus Ozo Emene, Abubakar versus Joseph. Citations all supplied. Going further, the law is also settled that once a claimant has successfully shown that he suffered personal injury as a result of a breach of a duty of care owed him by the defendant, the court will proceed to assess the damages claimed on available facts. Damages in the sense are of 2 main types, namely, first, special damages, which cover pecuniary loss, which has to be specially pleaded and proved, and it consists of out-of-pocket expenses and loss of earnings incurred down to the date of trial, and is generally capable of substantial exact calculation. Secondly, general damages, which the law implies and which is not specially pleaded, but sometimes claimed under separate heads in relation to the physical injury, which include compensation for pain, suffering, and the like personally sustained by the claimant. See Strabag Construction Nigeria Limited versus Ogworepe and UBA Limited versus Achora, citation supplied. Now, in assessing the case of the claimant in the light of the principles of law as set out in the foregoing, the first question that calls for resolution is whether or not the claimant has established that the defendant owed him a duty of care in the circumstances. Under the general law of tort, a duty of care is said to arise when 2 persons are so closely and directly related, and that the activities of one of them may involve an appreciable risk of injury to the other. Such a close and direct relationship exists between employer and employee, and thus, under the ordinary principles of tort, the employers owe a duty of care to their employees. See the case of Cabo Hair Limited versus Mohammed, 2014, Law Pavilion Electronic Law Report 23614. The undisputed fact is that the claimant at the time of the accident was in the employment of the defendant, whether on a continuous, part-time, or casual basis. On a general note, therefore, it is not difficult to hold, and I hereby hold, that the first defendant, being the employer, owes the claimant a duty of care. I now proceed to examine the evidence laid on record by the claimant and his witness in order to determine whether or not they is satisfactorily proved that the defendants failed to exercise proper duty of care owed to him, which resulted in the accident that caused him the permanent injury. The basis of the claimant coming to the conclusion that the defendant failed to exercise proper duty of care owed to him in the instant case, by my understanding of his case, is that the second defendant acted carelessly and or recklessly by switching on the machine without observing the safety precaution and without notice to the operator. The evidence of the claimant in this regard is contained in paragraphs 11, 12, 13, and 16 of a statement on oath. CW2 further testified that he was at the scene when the claimant was instructed to remove the blockage, and whilst the claimant still had his hand in the machine, the second defendant switched on the machine. The version given by the defendant's witnesses in denying the allegation of negligence are contained in paragraphs 3, 4, 5, 6, and 7 of the amended statement of defense. According to the defendant, the duty of the claimant was to remove waste at the base of the machine, and the claimant did not have the instruction of the second defendant to remove the blockage from inside the machine as he alleged. The defendant's further defense is that the claimant failed to take the safety precaution to prevent the accident. In reaction to the defendant's defense, the claimant testified further in paragraphs 3, 9, 10, and 11 of his further statement on oath that the clear instruction from the operator, one Taufik Balogun, was for him to clear waste from the base of the machine, and which had stopped the machine, and that prior to the accident, there had been no safety precautions in place. It is the further submission of learned counsel for the defendants that the testimony of the claimant is ingrained with inconsistencies with his pleading, and the claimant has not proved by cogent and credible evidence that the defendant had breached the duty of care owed to him to entitle him to the reliefs as claimed. By the combined effects of the provisions of section 131 to 133 of the Evidence Act, the claimant has the onus of proving that the defendants have breached the duty of care. I had examined the testimony of the claimants on the operation of the machine. I make reference to paragraph 10 of the amended reply of the statement of defense. The claimants made inconsistent assertions with regards to provision of safety precaution by the first defendant. His testimony in paragraph 10 is as follows, I quote, in further denying paragraph 5 of defendant's statement of defense, the claimant states that prior to his accident, there had been no safety precaution, no safety drill, nor was the function of the red safety button, which the defendants have repeatedly alluded to in paragraphs 5, 6, 13 of their statement of defense, been made known to the workers. The button was solely within the preserve of the operator, and they were never allowed to access it. While answering questions under cross-examination by the defendant's counsel, the claimant testified as follows, I quote, I'm not aware that there was a button in color red that I ought to have been used before putting my hand in the machine. The defendants on their parts consistently maintained through both witnesses that it was not the duty of the claimant to dislodge blockages from the machine, and the claimant was not instructed to remove the blockage on the day of the incident. While answering questions on the cross-examination, DW2, the operator of the machine, testified as follows. I quote, "The reason the machine stopped was because it was not stitching well. I had to stop the machine and called the plant supervisor. When the plant supervisor came, he switched on the machine to know the problem. It was at that point that I heard the claimant scream." His further testimony, still on the cross-examination, is that the safety button is used when there is an obstruction and there's need to continue the production. The machine had to be switched on to determine what the fault is. The fault cannot be detected if the safety button is switched on. Now, on the basis of the evidence adduced on both sides as set out in the foregoing, the court finds as firmly established the facts set out as follows. 1, that the machine stopped not because there was a blockage, but because it stopped stitching. 2, that the safety machine is applied when there is a blockage and there is need to remove the blockage. 3, that the fault cannot be detected if the safety button is switched on. 4, that the accident occurred when the machine was switched on to detect the reason it was not stitching. And since the claimant's duty is to remove waste at the base of the machine, he ought not to have placed his hands inside the machine. Therefore, on the basis of the preponderance of evidence led by the two sides, I am unable to come to the conclusion that the accident that occurred on the 17th of December 2012, causing permanent injury to the claimant's left hand, resulted from the negligence of the defendants. And I so hold. I said, I am unable to come to the conclusion that the accident that occurred on the 17th December 2012, causing permanent injury to the claimant's left hand, resulted from the negligence of the defendant. And I so hold. The conclusion the court must come to is that the claimant has failed to establish through cogent and credible evidence that the defendants acted in a way as to breach the duty of care, and that by the conduct of the defendant, they were careless and consequently occasioned the injury or loss is suffered. And I so further hold. Having failed satisfactorily, having failed, I hope, Ms. Shao, you heard the judgment clearly. The conclusion the court must come to is that the claimant has failed to establish through cogent and credible evidence that the defendant acted in a way as to breach the duty of care, and that by the conduct of the defendants, they were careless or consequently occasioned the injury or losses suffered. Having failed to satisfactorily establish a case of negligence against the defendants, I must, and I hereby resolve, issue 1 as set out against the claimant.
As the court.
Even though the claimant's action must fail, I however consider it proper to observe the well-established injunction of the appellate court that in order to avoid undue prolongation of litigation and to prevent unnecessary expenses, the trial judge should always, as a matter of duty, assess damages he will have awarded, even if his decision was against the party claiming damages. As such, I now proceed to determine the issue as to whether the claimant is entitled to the damages claimed and in what quantum. This is to the event that if it is held that this court is wrong to have held that the claimant did not establish a case of negligence, against the defendants. The claimant is also claiming $91,000 as cost of fitting functional prosthetic limbs, 20 million naira as general damages, and 15 million naira as for the persistent excruciating pain. The general principle that the claim for special damages is to be specifically pleaded and proved and includes out-of-pocket expenses, loss of earnings, and as such like. This is generally capable of exact substantial calculation. With respect to general damages, they are such which the law implies and need not to be specifically pleaded. This includes compensation for pain and suffering and the like, and if the injuries suffered were such as to lead to continuing of permanent disability, compensation for loss and future earnings. CUBA versus Achuri citation supplied. To support his claims for special and general damages, the claimant and his witness testified that after the alleged accident, the claimant was rushed to St. Gerard's Catholic Hospital, that as a result, he has been incapacitated, that he has since the accident been suffering from excruciating pains, and that he approached National Orthopedic Hospital on the 10th of March 2015 to explore the possibility of obtaining a functional prosthetic limb. To further substantiate his claim for damages, the claimant tendered in evidence as Exhibit C2 a medical report of National Orthopedic Hospital, Idigbe, Lagos, issued to the Principal Legal Aid Officer, Legal Aid Council of Nigeria, Kaduna, with respect to the issue of special damages claimed as payment of $91,000 as cost of fitting functional prosthetic limbs and 380,000 naira as cost of flight ticket to India. I note that Exhibit C2 tendered in support of the claim is a medical report written to the claimant's counsel, and the said sum being claimed was not stated, and there is no proof on how the claimant arrived at the sums. In other words, the claimant failed to prove these claims in his evidence before the court. In view of the claimant's failure to prove these claims, this court cannot therefore rely on a speculative and unsubstantial oral testimony as the basis for the grants of the claims. For the reason expressed in the foregoing, the claimant's claim for special damages must therefore fail. With respect to the claim for general damages, it needs to be restated that general damages capture such damages as the law implies or presumes to have accrued from the wrong complained of for the reason that they are the immediate, direct, proximate result of such wrong, as it did in fact result from such wrong directly or proximately and without reference to special character, condition, or circumstances of the claimant. In the present case, the unfortunate accident resulted in the loss of the claimant's hands, a permanent disability that he most likely will carry for the rest of his lifetime. He testified that the loss of that has led to his disability, has led to his inability to effectively provide for his family. In other words, productivity and consequently his capacity to earn income will automatically be affected and dwindle. However, for his inability to satisfactorily prove his claim of negligence against the defendants, this award cannot be granted. I should remark that since the claimant has elected to claim for negligence under the common law, the entirety of the submission of the respective learned counsel with regards to the purported claim under the defendants on behalf of the claimant under the ECA is inconsequential. In the very final analysis, my judgment is that the claimant's claim painfully lacked in merit and in substance. It shall be and it is hereby accordingly dismissed. Parties shall bear their respective costs.
As the court pleases. Your Lordship, we must thank you for the judgment just delivered. We appreciate the time taken, the efforts, and the industry that went into it. We are most grateful.
Thank you. The judgments, the copy of the judgments, what's today? Today is Wednesday, should be available by Friday or Tuesday at most, because I suspect Monday might be a public holiday. So let's stretch it up to Tuesday for the availability of the copy of the judgments, please. Thank you. Can you call the next case, please?
I'm most grateful.
Yes. The next case, please. I cannot hear you, Kaduna Division. You're on mute. They are on mute.
Let me check up on them, my lord.
They will be hearing me. It's just that I won't be able to hear them. Can you unmute your device, Kaduna Division? I think it's the network. Yes, can you call the next case, please?
Case number 4, NICS/Adamus Act 1, Kaduna State Ministry of Local Government, and 2, Kaduna State Local Government Service Commission. My lord, parties arguments.
Appearances, please.
My lord, I'm Aisha Mohammed.
Sorry, I didn't hear the name.
Respect, my lord, I'm Aisha Mohammed.
Aisha Mohammed.
Yes, my lord. My parents is for the judgment creditor applicant.
Yes.
With profound humility and respect, my name F.O. Enejo. My humble appearance is for the Ganishi First City Monument Bank.
No legal appearance for the judgment debtor.
Yes, my lord.
Ruling. Pursuant to an expert, you might have to move closer so that you can hear the court clearly over the microphone, please. Ruling, pursuant to an ex parte application filed by the judgment creditor in this Ganishi proceedings, on 8th of July 2021, this court made an order nisi on the 18th of October 2021, by which the sum of 9,364,000 naira only standing to the credit of the judgment debtors in the custody of the Ganishi First City Monument Bank PLC was attached for the purposes of satisfying the judgment debt awarded in favor of the judgment creditor by this honorable court in suit number NICN/KD/13/2017 between the judgment creditor and the judgment debtors. By the said order nisi, the Ganishi was further compelled to show cause why the order nisi should not be made absolute. Upon being served with the order nisi as required by law, the judgment debtors filed the instant application on the 2nd of November 2022, by which they sought an order to set aside the Ganishi proceedings and the order nisi made by this court on the ground inter alia that the order nisi was made without the consent of the Attorney General of Kaduna State. In turn, the Ganishi also, in response to the order nisi, filed an affidavit to show cause on the 12th of January 2022, whereby in a deposition, the judgment creditor was requested to furnish the Ganishi with better and further particulars of the account details of the judgment debtor in order to further search our database to confirm the existence or otherwise the judgment debtor's relationship with the garnishee. In response to the application of the judgment debtors and the garnishee's affidavits to show cause, the judgment creditor on the 10th of December 2021 filed a counter affidavit to the affidavit in support of the judgment debtor's motion and filed a further and a better affidavit in response to the garnishee's affidavits to show cause on the 17th of May 2022. In the same vein, the garnishee also filed a further affidavit in response to the judgment creditor's further affidavit on the 15th of June 2022. I have thus given a careful consideration to the motion and the totality of the processes filed to support and oppose them. I have also exhaustively considered and taken due benefit of the totality of the written and oral submissions of learned counsel for the contents inside, which I need not recapitulate here. By my understanding, the pertinent issue for resolution is, I quote, whether the consent of Attorney General of the state as stipulated in Section 84 of Sheriffs and Civil Process Act 2004 before commencing the garnishee proceedings to attach the monies is applicable to monies deposited into the garnishee bank herein, a commercial bank, by the judgment debtors who are public officers and thereby robbed the honorable courts of jurisdiction to hear the matter. As I proceed, I shall endeavor to make specific reference to the submission of learned counsel as I consider appropriate. It is pertinent to state at first that on the current position of the law, it is now well settled that even though a judgment debtor is not contemplated as a party to garnishee proceedings at the stage where the judgment creditor seeks to obtain an ordinancy, for the obvious reason that such an application is usually made ex parte. However, at the stage where the court is to consider whether to make the order absolute or not, the judgment debtor becomes an active participant in the proceedings. This is more so having regard to the requirements of the provision of Section 83 sub 2 of the Sheriffs and Civil Process Act, which makes it mandatory for the judgment creditor to serve the ordinancy on the judgment debtor. This invariably is so as to enable the judgment debtor appear in court on the adjourned date to be so heard if he so desires before the order is made absolute. See the cited cases. As a general principle of law, and as correctly submitted by learned counsel for the judgment debtors applicants, a court has no legal competence to reverse itself or set aside its previous order or judgment, except where such order or judgment is a nullity. A court's order can be regarded as a nullity, where, for instance, the court had acted without jurisdiction, or the judgment or order was obtained by fraud, or where there has been non-compliance with a fundamental procedural rule, and this has led to breach of fundamental right to fair hearing. See the cases of Okafor versus Attorney General Anambra State, the case of Sanusi versus Ayola, the case of ACB Limited versus Alao, the case of Purification Techniques Nigeria Limited versus Attorney General Lagos State. In the instant case, the judgment debtors applicants have contended that as at 18th of October 2021, the order of garnishee against them for the judgment sum, the court lacked the jurisdiction to make such order because the consent of the State Attorney General was not obtained in order to assess the funds of the judgment debtors in the custody of the garnishee. FCMB has vitiated the garnishee proceedings and the order made by this court by the provisions of sections 83 and 84 of the Sheriffs and Civil Process Act. Before I determine this issue, it is pertinent at first to find that the garnishee FCMB, by virtue of the further affidavits to show court, cause, which was filed on her behalf on the 15th of June 2022, has admitted that she holds certain funds of the judgment debtors in her custody. I make reference to the depositions in paragraphs 3B and C of the said further affidavit to show cause. By this deposition, it is therefore not in doubt that indeed it was appropriate for the judgment creditor to have proceeded against the garnishee as the entity that custodies funds belonging to the judgment debtors, against which an order absolute is now being sought to be attached. Learned counsel for the judgment debtor applicant in his argument cited the provisions of Section 84 of the Sheriffs and Civil Process Act, Cap 6, Cap SC of Laws of Federation of Nigeria 2004, and further argued that the proposition of the law is well settled that the consent of the Attorney General must be obtained before garnishee order nisi can be validly made to have legal effect pursuant to the mandatory provision of Section 84 of the Act. The cases of Njeku versus Kogi State, Ministry of Commerce and Industry, the case of Central Bank of Nigeria versus Hydro Air Property Limited, Central Bank of Nigeria versus Amcon and others, and the cases Fireshare versus EFCC and another were cited. All the citations are supplied in support of his proposition. Learned counsel submitted that from both the statute and judicial authorities cited above, the garnishee proceedings instituted by the judgment creditor did not follow due process of law and acted contrary to the very sacred principles of law governing the commencement of such actions. Learned counsel further argued that the amounts to be attached by the garnishee order nisi belong to a third party and not to the applicant. Learned counsel urged the court to hold that the garnishee order nisi made is void and to set same aside as it is not initiated by due process of law. In reaction, the judgment creditor respondent had deposed to paragraph 7, 8, and 9 of the counter affidavit and paragraph 9 of the further and better affidavit in response to the garnishee affidavits to show cause that the judgment debtors operate an account with FCMB and that the judgment sum in the custody of the garnishee bank has never been under the custody or control of a public officer. For the purpose of clarity, I take liberty to reproduce the clear and unambiguous provision of Section 84(1) of Sheriffs and Civil Process Act, SUPRA, as follows. Quote, where money liable to be attached by garnishee proceedings is in the custody or under the control of a public officer in his official capacity or his custodial legis, the order nisi shall not be made under the provisions of the last preceding section unless consent to such attachment is first obtained from the appropriate officer in the case of money in the custody and control of a public officer or of the court in the case of money in custodia legis, as the case may be, end of quote. The appropriate officer referred to in that subsection is further defined in subsection 3 as follows. I quote in this section, appropriate officer means A, in relation to money, which is in custody of a public officer who holds a public office in public service of the Federation, the Attorney General of the Federation. B, in relation to money, which is in the custody of a public officer who holds a public office in the public service of the state, the Attorney General of the state. End of quote. The relevant phrase for the purposes of this application is, I quote, money liable to be attached by garnishee proceedings is in the custody or under the control of a public officer in his official capacity. Thus, where the money liable to be attached by garnishee proceedings is in the custody or under the custody of a public officer in his official capacity, that ordinance shall not be made without the consent of the appropriate officer. Now, the relevant question that needs to be resolved is, can the monies in the garnishee bank, FCMB PLC, be said to be in the custody or under the control of a public officer in his official capacity? One obvious aspect to note is that the above stated garnishee bank is a commercial bank. It is logical, and common sense supports the fact that garnishee banks are not public officers. Then, monies deposited in a commercial bank by whosoever, either public officers or private persons, are in the custody or under the control of the said commercial bank, which the garnishee bank, which is the garnishee bank in this application. In purification techniques, Nigeria Limited versus Attorney General, Lagos State, 2004, 9 Nigeria Weekly Law Report, part 879, page 665 at 680 to 681. It was held thus. I quote, in the instant case, the monies held by respondents in the garnishee bankers are not under the custody or control of the respondent, a public officer. Consequently, such monies are not subject to the provisions of Section 84 of the Sheriff's Civil Process Act as contended by the respondent, end of quote. See also the case of Utavi and others versus Capital Development Authority and others, 2019, Law Pavilion Electronic Law Report at 49095. The Apex Court and Sonny Abacha Foundation for Peace and Unity and others versus United Bank for Africa PLC, 2010. Law Pavilion Electronic Law Reports at 3002, also held as follows, I quote, any money paid to a bank belongs to the banker from the moment of such payment, thus creating as between the banker and the customer a debtor-customer relationship. Indeed, what the banker pays out is its own money. Thus, when money is paid by a customer to a bank, there is a contract between the banker and the customer in which the banker receives the money as loan from the customer against the promise by the bankers to honor the customer's check and order others of the customer, end of quote. Thus, by this pronouncement, the Supreme Court has clarified the issue of depositors' money in a commercial bank by stating that once the money is received by the bank, it no longer belongs to the customer, but to the banker. It follows, therefore, that the monies so attached by the ordinance are in the custody and under the control of the said garnishee bank. Such monies remain the property of the bankers under their custody and control and payable to judgment debtors until a demand is made. See also the cases of Balogun versus MBN and Yesufu versus ACB citation supplied. In the present case, the monies is in the control of FCMB, the garnishee, and the garnishee, a commercial bank, cannot by any stretch of imagination be referred to as public officers in their official capacities. They are not public officers as defined. In other words, they are not public officers as defined by Section 84 of Sheriffs and Civil Process Act. Therefore, the Section 84 supra is not applicable in the instant suit. And I so hold. On the basis of the foregoing analysis, therefore, having found and come to the conclusion that obtaining the consent of a public officer is not applicable in cases where as in the instant case, monies to be attached is not in the custody of a public officer, but a garnishee bank, that is a commercial bank. The application to set aside the earlier order nisi made by the court is hereby refused. It is significant to state that a garnishee, where it is a financial institution on whom an order nisi is served, is under a burden duty to declare on oath before the court in the affidavit to show cause any of the following facts. One, that she holds funds belonging to the judgment debtor in her custody sufficient to meet the judgment sum, or B, that the judgment debtor has no account at all with the bank, or that the particular amounts described in the order nisi does not exist in the bank or are so described, or C, that the judgment debtor has an account with the bank, but that the amount in the account is insufficient to meet the judgment sum, or that the account is in deficit altogether. The essence of this is to enable the court form an independent opinion as to the ability of the garnishee to satisfy the judgment debt, either in full or in part, or to determine what further directions to make in the circumstances. See the case of Oceanic Bank PLC versus Oladipo, citation supplied. I had proceeded to examine the depositions in the further affidavits to show cause filed by the garnishee. It is disclosed So I'll just take it. Sorry, it was a network issue here. Are we still there, please? Hello, are we still there? Mrs. Lawal, if you're still there, are the council still there? Mrs. Lawal,
Yes, my lord.
the council are still there.
Everybody's there. You seem to be on with them, my lord. Let me check them.
Okay, so I'll take. Okay, their phone is on mute, so I'll just take the last paragraph of the ruling.
Okay, my lord.
Cardinal Division, can you unmute so that I'll just take the last paragraph?
Let me go and tell them, my lord.
Okay. Sorry about that. There was a network issue. The concluding paragraph is all I'll take now. I proceeded to examine the depositions in the further affidavits to show costs filed by the Ganishi Bank. It is disclosed in paragraph 4C thereof that the Ganishi maintains the accounts of the defendants and that there is enough credit balance to satisfy the judgment sum. On the basis of the following analysis, therefore, I am satisfied that there is no impediment in the way of the judgment creditor and is therefore entitled to be paid the judgment credit of 9,364,000 only from the accounts of the judgment debtors domiciled with the Ganishi Bank in account number 33064-806-012, which is stated to have enough sufficient credit balance as at 15th of June 2022. On the whole, the order made by this court on the 18th of October 2021 is hereby pronounced absolute upon terms already set out in the foregoing, that is, that the Ganishi Bank shall pay to the judgment creditor forthwith with the judgment debt of the sum as earlier stated. I make no award as to costs.
As court pleases.
Thank you. I hope the council are still there.
They are there, my lord.
Okay, sorry about the interruption. I wonder what there was power failure, so it's cut off the Wi-Fi. So that's an issue there.
We're very grateful, my lord, for this sound ruling.
So like I stated in the previous judgments, you wait up till Friday before this. If it's ready, they will call on you before Friday, but Friday will be the deadline for me to send it there.
I'm most grateful, my lord, for this sound.
Thank you. The court will rise, please.
Thank you.